In Florida, a lawsuit was filed against the chocolate maker Hershey, claiming that they misled consumers in their packaging, specifically seasonal versions of Reese's peanut butter cups. Now, what was the issue they had with the peanut butter cups? Not taste, not some kind of hidden ingredients or something that will impact the health of the consumer. No. Their grievance with Hershey was that the candies as they appear in the packaging are deceptive advertising because the candies themselves don't have as much aesthetic detail on them.
Come on!
You know, I went to law school thinking I am so excited to work in a field where important matters are litigated that are really making a difference in people's lives. And then you hear about cases like this one. Spoiler alert, it was also very recently dismissed by the court. Let's get into it. Okay, so what is going on here? In May of last year, 4 plaintiffs from Florida filed a proposed class action lawsuit against Hershey, alleging essentially false advertising. According to the complaint, they all bought some kind of seasonal version of Reese's peanut butter cups. And when they did, they saw that the packaging featured a quote-unquote cool design on the candy. This is what they allege prompted them to buy the candy. They say that had they not been under the impression that the candy had these details on them, they wouldn't have bought them. And so they allege 5 different offending candies. The Reese's medal as part of their sponsorship of the US Olympic team, a Halloween version in the shape of a pumpkin featuring a jack-o'-lantern face carved on the front of it, another Halloween version but featuring a ghost with its eyes and mouth carved out of the chocolate, a third Halloween version featuring a bat shape with eyes cut out, and one in the shape of a football, presumably for Super Bowl Sunday, but without the laces cut out. And so they filed this complaint alleging that these violate Florida's Deceptive and Unfair Trade Practices Act. Specifically, they say this packaging misleads reasonable consumers by engaging in unfair and deceptive practices. But let's read some more of the specifics just so that we are super clear about what is going on here. Now, all 4 of these plaintiffs' claims are basically the same, so let's just look at one of them. So looking at the first of the 4 plaintiffs in the lawsuit, it says that on October 29th, 2023, while shopping at a Publix grocery store located in Broward County, Florida, Plaintiff Nathan Vidal saw the Reese's peanut butter pumpkins for sale and believed that the product contained a cool-looking carving of a pumpkin's mouth and eyes as featured on the product packaging. Relying on the picture on the product packaging, Mr. Vidal purchased 3 bags of Reese's peanut butter pumpkins for approximately $8 each. Mr. Vidal also purchased a bag of Reese's white pumpkins for approximately $8. However, the Reese's peanut butter pumpkins and Reese's white pumpkins that Mr. Vidal purchased did not contain any of the artistic carvings of the mouth or eyes as pictured on the label, and they were all blank. Mr. Vidal was very disappointed and would not have purchased the Reese's peanut butter pumpkins and Reese's white pumpkins products if he knew that they did not have the detailed carvings of the mouth and or eyes as pictured on the product's packaging. Now, there are plenty of cases where consumer protection lawsuits are necessary because a company is using tactics on a grand scale that take advantage of consumers. For example, the FTC has gone after companies that make it too difficult to end a subscription. And that's because it's become such a widespread problem for consumers with the rise of subscription services. For my part, just last week, I noticed a sneaky charge pop up from a subscription that I could have sworn I canceled months ago. I haven't been using it, so it's been a huge waste of money. But the good news is that there are some stopgap measures that can be taken in a situation like that. So the first thing I did was to move the payment over to a privacy card so that I could get control over it again. Privacy is a service that helps you feel safer when you shop by protecting your payments with virtual cards. And I'm really happy that they are the sponsor for today's video. Privacy helps you create virtual card numbers for purchases for a variety of uses. These can be merchant lock cards that get locked into one place, meaning if there's an attempt to use it elsewhere, it gets denied, or category lock cards so that they can be only used for certain types of purchases like dentists, pharmacies, groceries, or entertainment. Or they can be things like single-use cards that basically burn the card after you use it once. And Privacy has a free plan with no transaction fees for domestic purchases and a few paid plans with more advanced protection features. Now, there are a few things that I really personally like about Privacy. Number one is that using their product hides your real card details from websites and businesses. And that means you can stay safe from data breaches and shady sites. And if you want extra protection, you can either pause cards between purchases or set a spend limit, another key feature of these cards. Second, privacy says that they never sell customer data. Instead, their revenue comes from merchant fees, not your information. And if you need help, their support team is made up of actual real humans. So if you want a little bit more peace of mind in your online transactions and get a $5 sign-up bonus for your first purchase through Privacy, go to privacy.com/legalbytes by following the link in the description below. Once again, that's privacy.com/legalbytes. And thanks again to Privacy for sponsoring this video. Back to the video and back to why this whole lawsuit is different from other consumer protection lawsuits that are actually worth something. So basically, all of this boils down to, so what? So you bought a product, you were disappointed by one of its features, so what? There are plenty of times when we buy a product and we're disappointed by some aspect of it that happened to be marketed to us. That's not necessarily enough to support a lawsuit. For example, you walk down the street in New York City and see a cafe with a sign in the window that says, "World's greatest cup of coffee."
You did it! Congratulations! World's best cup of coffee. Great job, everybody. It's great to meet you.
If you go in there because of that sign and buy a cup and realize it's actually crap, that doesn't necessarily give you basis for a lawsuit. Now, if you bought something because it was marketed as one thing, but then after you purchased, you realized it was something completely different, that's a different story. For example, when CarShield had to fork over $10 million for deceptive advertising over what it was that their auto warranty plans would actually cover. But the key difference here is whether or not the thing that's gone wrong is actually material to the product. So for example, if this complaint had alleged something like, these peanut butter cups are marketed as having peanut butter in them, but we looked at the ingredients list and there's actually no peanut butter in them. That's maybe more in line with what we would expect to see in this kind of a lawsuit. But here, these plaintiffs allege that they would never have purchased these seasonal peanut butter cups were it not for the packaging that made them think they were getting something more detailed. First off, does anyone actually believe that? Like, there's nothing about how amazingly delicious and guilt-inducing yet satisfying these candies are that would have enticed them to buy it in the first place? Personally, I don't believe that any of these plaintiffs would never have bought these candies but for thinking that there was going to be a jack-o'-lantern face on it. Second, I sort of touched on this earlier, but where is the harm? Maybe this just says more about me than anything else. But the difference in experience between eating a peanut butter cup that has football laces etched onto it and a peanut butter cup that doesn't have football laces etched onto it is all of maybe, 2 seconds. That's about the time it takes to open the package, look at it, and put it in your mouth. The part of the experience that really means anything, arguably anyway, at the end of the day is the taste. Maybe the nutritional value, depending on the circumstances or the allergens of the product. But it's not like when you open up the packaging and see that this ghost doesn't actually have a face, that suddenly this product is somehow rendered useless. Like, none of these plaintiffs allege that they threw away their peanut butter cups after seeing that they didn't have as much detail as they were hoping it would. To the contrary, you still have a very useful peanut butter cup that is about to go into your belly just the same. And I would suspect that all of these plaintiffs probably still ate these peanut butter cups of sadness. Now, do some of these look hilariously like something Amber Heard might leave on the bed for Johnny Depp?
Right, and they were making a wonderful point of just how funny it was that I thought that some human being had actually dropped a grumpy, pardon the term, onto the bed.
But would most people still eat it anyway? Also, yes. And you want to know how I can say that? Because this is one of those times where the best place for this to be corrected, if in fact it does need to be corrected at all, is in the market. In other words, if this were a serious problem for consumers, they would simply not buy it. This product would appear for one season and then disappear the next. Because when you buy it once and realize how it kind of looks hilariously bad in comparison to the packaging, it's not like you forget that the next time you're in line at Walgreens with cotton swabs and impulse buying some peanut butter cups at the register again. That's because marketing can only do so much for a product before hype wears out and the future of a crappy product dwindles. Now, I spoiled this in the beginning, but yes, the court just dismissed this case. On September 19th, the court dismissed it for lack of standing, and basically the reasoning is for what I was essentially just describing. Pro tip, when the order starts off with a summary of the allegations like this, you kind of know where this is going to go. Plaintiffs claim they bought chocolate products they thought included cool carved designs, but were disappointed when the products did not include those designs and therefore, in their view, were not so cool. Okay, but aside from that, one thing that every plaintiff needs to have in any lawsuit is something called standing. That basically means that the plaintiff has the right to sue. One thing that can impact a plaintiff's standing is whether or not they were actually harmed. If there's no harm, they have no standing, and the case has to be dismissed at least as to the plaintiff that doesn't have standing. And here, the court writes, Hershey argues that plaintiffs have not pled an actual concrete economic injury because they were not denied the benefit of their bargain for the specific products they purchased. In other words, plaintiffs paid for a consumable good, and in return, they received a delicious edible Reese's product. Now, the plaintiffs countered by arguing they have sustained an injury in fact because they alleged that they would not have purchased the Reese's products if they had known that they did not have the detailed carvings as pictured on the packaging. But ultimately, the court agreed with Hershey when the judge wrote, plaintiffs do not allege the products were unfit for consumption, do not taste as plaintiffs expected, or otherwise were so flawed as to render them worthless. Rather, plaintiffs allege that they were disappointed that the products they purchased did not have the detailed carvings pictured on the product packaging. And the court continued, this is not enough to plausibly allege a concrete economic injury for purposes of Article 3 standing. And on top of that, the court also said that another problem is the fact that the plaintiffs never alleged anything about the difference in value with or without the decorative carvings. In other words, did they end up paying more for these peanut butter cups simply because they were seasonal, or were they essentially the same price? Now, one thing to note is that at least one of these plaintiffs bought the candy after the holiday that candy was aligned with. Specifically, Plaintiff Eduardo Granados bought the Halloween candy on November 2nd, 2023. And if you know anything about Halloween in the United States, you know that on November 1st of every year, all of that candy gets marked down at a steep discount because stores are trying to clear their shelves for the next holiday. So in at least one of these cases, there's probably a greater likelihood that the candy he bought was actually marked down from typical retail value, not the other way around, because it was seasonal. But anyway, back to the court's order, the judge said, in short, accepting all of plaintiff's claims in the complaint as true and viewing all those allegations in the light most favorable to plaintiffs, this court finds that plaintiffs have failed to allege facts demonstrating a concrete injury. Therefore, they don't have standing, and this case is properly dismissed. Now, something else that was interesting to me was that in the reporting on this dismissal, at least one of the journalists writing about this talked to the plaintiff's counsel. And in that conversation, plaintiff's attorney said that they intend to amend the complaint. He said the court is merely saying that the plaintiffs did not expressly allege in the complaint that the products are worthless to them or that they paid a price premium and allowed plaintiffs to amend the complaint, which they will be doing. I don't think that this attorney read the entire order, at least maybe not fully, because that's not really correct. I mean, yes, as we already talked about, the judge said there was nothing about the products becoming worthless because of this or that the consumers paid anything extra because these were seasonal products. But, and this is kind of a big deal for the lawyer to get wrong here, the judge did not allow these plaintiffs to amend this lawsuit. Rather, the judge said that the complaint was dismissed without prejudice because it's not dismissed on the merits of the claims. Now, typically, when something is dismissed without prejudice, it is usually paired with a grant of leave to amend the complaint. But technically, without prejudice just means that the claims can be brought again. And just as technically, in order to get leave to amend for a case that has been dismissed without prejudice, you have to ask for it in the right way at the right time. And the judge said the plaintiffs in this case did not do that. And so because of that, the judge is not allowing the plaintiffs to amend the complaint and continue in this case. So basically, where does this leave the plaintiffs here? Essentially, they can file a whole new lawsuit with these claims, but they can't amend this one. And given that the statute of limitations for claims under this statute in Florida is 4 years, it looks like plaintiffs have around another 2 years to refile before their claims expire. That said, personally, I think that even with a total rewrite of this complaint, with everything that the judge had said about the things that were wrong that need to be fixed in order for it to be okay, the likelihood that the plaintiffs see a different outcome seems slim to none. But those are my thoughts. What do you think? Is this whole lawsuit just silly, or do you see some reasonable consumers out there actually being harmed by what Hershey is doing with this packaging? Let us know in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see coverage of more crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next one is uploaded. And if you're really enjoying the content, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.